Welcome to AP Daily. In today's video, we're going to be looking at Marbury versus Madison, one of the really key important court cases in U.S. history. I'm Dr. Rhonda Webb, and I teach AP U.S. History at Lassiter High School in Marietta, Georgia. In today's video, we're going to be looking at one of these key concepts that is establishing federal power over state power using the Supreme Court rulings. In my classroom, I often do case studies where I have a kind of a format that I use for a lot of the pivotal court cases throughout the course. But I want to kind of share with you a little bit today in one of those, Marbury versus Madison. And in my class, when we do this case study, we always focus on the opinion that the Supreme Court's justices have written. An opinion is almost like an essay explaining why they voted the way that they did in the case. So let's look at Marbury versus Madison. And what it's really dealing with here is actually federal power versus state power. And we've spent a good bit of time in time period 3 looking at the Articles of Confederation and the shift of that power from the states to the federal government under the new Constitution. And that's going to be really debated here in Marbury versus Madison. So what's the background of the case? Well, back in the election of 1800, we had the transfer of power from the Federalist Party when John Adams lost the election to the Democratic Republicans when Thomas Jefferson won. So after the election in November, the new president at that time didn't come into office until March. So during that period of months, John Adams began to appoint lots of federal judges who, of course, were going to be Federalists because the judges serve for their whole lives. So we would refer to these as the midnight judges because they were kind of last-minute actions that the president was taking while he was still in office. So the way that the system worked is once he appointed a judge, then he would sign a commission, and then it was up to the Secretary of State to deliver that commission to the person who's been appointed to be the judge. It's almost like a contract in some ways for a new job. So John Marshall at the time was John Adams' Secretary of State. He also had gotten appointed to be the new Supreme Court Chief Justice. So he was kind of filling both roles at the same time. So Adams is busy signing these commissions, and suddenly time runs out. And one of the last few that he had signed was for William Marbury to become the new Justice of the Peace for Washington, D.C. But time ran out, and John Adams was leaving office, and the commission was never delivered. He signed it, but it was never delivered to William Marbury. So that's where the question's going to come in. Does he deserve this job even though he never actually received the commission? So if we look at the breakdown here, so this is when John Adams is still president, and I've color-coded this by party. So the green here is representing the Federalist Party. Adams is the president, John Marshall is Secretary of State and Chief Justice, and then William Marbury. They're all Federalist. Well, as soon as Thomas Jefferson comes into office, we've got the Democratic Republicans now in the White House. Thomas Jefferson, he's got James Madison as his Secretary of State. We've still got a Federalist Supreme Court, and then poor old William Marbury, he never got his commission for his job, so he doesn't know what to do because he feels like he deserves it. So if you look at this arrangement here, he's probably not going to get a lot of help from the executive branch, but he might get some help from the judicial branch because they're of the same party. So he ends up suing James Madison. That's where we get the name Marbury versus Madison, trying to get this job. So I want us to look at the ruling here briefly that John Marshall has issued in the case. So in the opinion, it's basically an essay where John Marshall is explaining why he has made the decision that he has made. So let's look at this case. So John Marshall, he's going to deliver the opinion of the court. And in the beginning, he's talking about what are the questions that we need to answer here. So I've kind of summarized that for us in a little box. The first question, does William Marbury have a right to the commission? John Marshall says yes, he thinks he does. Does U.S. law allow William Marbury a remedy? A remedy is almost like a solution to the problem. William Marbury believes that he's been wronged. Does U.S. law provide for a remedy? Marshall again says yes, that when people are injured, then laws of the United States allows them to have some sort of recourse. The question is that recourse really supposed to come from the Supreme Court? So that's going to be the big question that has to be resolved here. So he goes on in the opinion, and these are quotes from the opinion. The Constitution vests the whole judicial power of the United States in one Supreme Court and the inferior courts as Congress shall from time to time ordain and establish. That's going to be Article 3 of the Constitution, where they establish these courts. So it's left up to the Congress to create the federal courts, but it goes further and says exactly what powers the Supreme Court will have. So then it says the Supreme Court shall have original jurisdiction, meaning court cases start in the Supreme Court in cases affecting ambassadors and public ministers from other nations, or when there is a state that is a party in the case. So if a state, if they're at odds with one another, then the Supreme Court's going to be dealing with that. All other cases, the Supreme Court shall have appellate jurisdiction, meaning appeals, where it's already been heard in a lower court. So the plain import of the word seems to be that in one class of cases, its jurisdiction is original, and then the rest are going to be appellate. Okay, to enable this court then to issue a mandamus, that's a funny word, and it means basically a mandate or a document that would force another government official to take some action. If this court is supposed to issue this writ of mandamus, it must be shown to be appellate jurisdiction because that's what the Constitution says. Okay, so then it goes through here. And it says the question whether an act repugnant to the Constitution can become the law of the land is a question deeply interesting to the states. Okay, so when this is saying here that writs of mandamus, that's not listed in the Constitution as power. So he's saying this is going to be a big question for everyone to pay attention to. It's either going to be the laws, right, are going to have the same weight as the Constitution, or the Constitution is going to be a little bit more powerful. And so then he says it is clear that when there are two laws in conflict with one another, the courts must decide the operation of each. So if a law is in opposition to the Constitution, in a particular case, the court must determine if these conflicting rules who's going to govern the case, and he's saying that that is the judicial duty. Now let's think back. What did we just talk about with the Alien and Sedition Acts? When there was a state that viewed this federal law as being unfair and unconstitutional, Thomas Jefferson got the Virginia legislature to pass the Virginia Resolves. And in that situation, the state was declaring a law to be unconstitutional. Well, what's at issue here? There was a law, the Judiciary Act of 1789, that among other things, one of the provisions of this allowed the Supreme Court to issue a writ of mandamus. But John Marshall is saying this part of the law doesn't match what the Constitution says, therefore this law is no longer in effect. So what he has done here, he has taken the wording of the Constitution and this power of states versus federal government, and he has shifted that power back to the federal government away from the states. Wow, think about what Thomas Jefferson is thinking. Jefferson had claimed that power. The Democratic Republicans had claimed that power for the states. John Marshall has now just taken it back, and poor William Marbury has been sacrificed. So he's got here this phrase in the Constitution. It confirms and strengthens the principle that that if a law is repugnant or opposed to the Constitution, then that law is void, and the courts as well as other departments are bound by that instrument. The rule must be discharged. So this law must be struck down. So this is a pretty clever ruling on the part of John Marshall, because he has now taken that power back for the federal courts, and we call that judicial review. Really, really emphasize that in your notes. So what should we take away from all of this? Well, this gets into loose versus strict construction, and it's almost like John Marshall has beaten Jefferson at his own game. The Democratic Republicans were all about strict construction. Well, he's kind of used strict construction to actually claim more power for the federal government. So this creates even more bitter rivalry between the political parties, federal versus state power, and loose versus strict construction. So next time on AP Daily, let's look at the Louisiana Purchase and some of the discussions between Thomas Jefferson and Lewis and Clark.